Hey patent friends, I'm doing a talk for some clients tomorrow about patent strategy for startups, and so I wanted to record this as a dry run to help prepare me for the talk. So what I'm going to be talking about is first defining what are patents and intellectual property, what can be protected by patents, why should startups even care about patents, which is really important. A lot of times that's counterintuitive. Also just sort of basic patent strategy for startups compared to big companies and individual inventors. It's actually very different, and there's a lot of things that are counterintuitive about that as well. Also, the patent process, give an overview of that, and also how people at companies can help, whether they be the inventors, the engineers, the C-suite folks, how they can help engage in the patent process. So I'm Dylan Adams. I'm a patent attorney at the firm of Davis Wright Tremaine, and my job as a patent attorney is to help companies of all sizes protect their ideas and inventions with patents. And I do that by planning patent protection, drafting and filing patent applications in the United States Patent and Trademark Office, and then working them through the examination process. So as a patent attorney, I have to understand the inventions of my clients as well, if not better than them in a lot of ways. So to be a patent attorney, you are required to have a technical background. So for me, I have a master's in electrical engineering, undergrad degree in biochemistry and microbiology. I'm also the author of the book Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. So when it comes to intellectual property, there are four main types of intellectual property. There's going to be patents, copyrights, trademarks, and trade secrets. Now, patents and copyrights are kind of diametrically opposed. So patents are going to protect utilitarian inventions. Copyrights protect artistic works. Now, when I say that they're diametrically opposed, it doesn't mean that one single product can't protect both. So for instance, if you have a utilitarian object like a chair, the design of the chair would need to be protected by patent. Whereas if you had an artistic design on the fabric or say a carving on there, that may be protectable with copyright. So there may be an overlap in a product, but those are protectable by different things, by patents, which are utilitarian protected things, or copyrights, which are artistic works. Trademarks are kind of off on their own. Trademarks protect goods and services in relation to specific marks. And trademarks are intimately associated with specific goods and services. That's what's really important. So you can have a trademark on something and it only is going to cover what you're using that in relation to as far as your goods and services. Trade secrets can protect things, really anything that is going to be secret. A lot of times it's going to be formulas, methods of making products, recipes, processes, client lists. When you're developing technology and things like know-how, that's sort of personal to the company. As far as developing technology, that can be a way to protect things before you file a patent application. But what's important to understand about trade secrets and patents is that at some point, at the very least, when an application issues as a patent, it's going to become public. And so at that point, it won't be a trade secret anymore. Trade secrets are only things that you actually are able to keep secret and take reasonable steps to keep secret. So you cannot have a patent on something and also have it be a trade secret. And that's important to understand when it comes to planning patent and trade secret protection. What do you want to keep as a trade secret? What do you want to have patented? And where do you want to focus your energy? A lot of times, if things aren't going to be discoverable in terms of, say, for instance, if you have a manufacturing method and there's no way to reverse engineer that process, say by like opening up the product and figuring out how this was done, you may want to keep that as a trade secret instead of put it in a patent application, because you would have to disclose all of those details. Okay. So when it comes to the rights of a patent, what does a patent actually allow you to do? So it allows you to exclude others from making, using, selling, offering to sell the invention throughout the United States, or importing the invention into the United States. It's important to understand that this is not a right to actually do something. So it doesn't give you the right to actually perform the process or actually to make the invention. So a great example here is, so say like with the FDA. So you may come up with a new compound for treating cancer and an associated method. Those could totally be patentable. But if you get a patent on that compound or a method of using that compound, that does not mean that you're actually allowed to, because of having a granted patent, actually use that process, right? So you would have to get FDA approval in order to use the compound to treat patients that way. So it's always important to understand that patents are a negative right. It allows you to exclude people from doing things. It doesn't give you the right to actually do something. Now, why should startups actually care about patents? The first thing that people usually think is, oh my gosh, I want to stop people from doing things. You think about this monopoly, this ability to exclude folks. And yes, that's the basic patent right that I just talked about. But for startups, that's one of the least important things and one of the things that provides the least value when it comes to growing a patent portfolio. So for instance, licensing. If you have a pending patent application or an issued patent, you can license that to somebody. You own the patent still, but say in exchange for a flat fee or for ongoing royalties, you can license the patent rights. Also, you can sell patents. So if you own a patent and you want to sell it to somebody else, you can gain profit through that. In 2016, there was a study done, and of public sales, the average was $360,000 per patent. So selling patents can be quite valuable. Depends on the industry and the product. In that study, for example, that's going to be public sales. So it's going to be kind of skewed. There's a lot of private sales, and I'm sure there's a lot of sales that are going to be a lot less than that, maybe even a lot more than that. Another important one is sort of the book value. So having a portfolio of patent assets, that's going to be really important in terms of valuing a company. And in terms of, for instance, if you're going to get loans, if you're going to be attracting investors, just having a patent portfolio increases the value of a company. And especially for startups, that's extremely important. But there's a lot of sort of passive things that come with having pending patent applications and issued patents that are really important that a lot of times folks don't think about, especially startups. And these tend to be some of the most important things to startups and getting traction with the company. So one is the positive marketing purpose, whether it be to attract investors, which is obviously really important, or to attract customers, partners, anybody you're going to be collaborating with, knowing that you have a patent portfolio, that you are, you doing these great, interesting things, that's attractive to folks, okay? That's going to be attractive. Just being able to say you're patent pending or you have an issued patent, there are really positive marketing things that go along with that. And it's important to actually market that you have pending patent applications or that you have issued patents. That's very important. Also, on the flip side of that is instilling fear in competitors. So just even having a pending patent application, a lot of times pending patent applications, especially provisional applications, they aren't going to be published. People don't know, well, what's patented, what's not, what's going to be protected if an application actually issues on this. And a lot of times it'll make them hesitant to get into that field and make those sort of products or become a competitor if they don't know what's going to be protected. And it's hard to quantify the value on that. How many people have you scared off from making competing products? How many people have you scared off from doing something, that's similar in terms of business model? It's hard to know about that. Also, too, so you can stop people from getting patents on similar things. So by default, after you file a patent application from the earliest priority date, 18 months after that, a application is going to publish and be publicly available. Or at the very least, it's going to, when it issues as a patent, it will be published then. So those publications, regardless of whether you do anything or not, just passively can be used against other people to stop them from getting issued patents. So as I'll kind of go in more detail later on about the patent process, when a patent examiner is looking at somebody else's patent application on similar technology, they're going to find your published patent application, even if it never issues as a patent, or the publication of your issued patent, and say that what they have is potentially not new and it's not non-obvious over your prior art and maybe a combination of other prior art, and will not grant them their patent. So just passively, you can stop people getting patents on similar technology, which is really important. It's great to think about patents as kind of an IP arms race as well. The best way to defend against a company that has a patent portfolio is have one of your own. And I work with clients all the time where we do this, where the other company has a big portfolio, we have a big portfolio, and say, okay, instead of just suing each other and creating this this apocalyptic, expensive patent war, hey, let's cross-license. And maybe sometimes it's an overture to an acquisition. Maybe the startup will be acquired by the bigger company, or if it's a large startup, maybe they'll acquire the other company. So patent assets can be really important for those things as well. Now I want to give you some specific data for startups, and these are really important things. Like, this is why we are here. So there was a great PitchBook study recently in 2023. So for instance, companies with patent portfolios. They had 40 to 60% larger funding rounds. They had 78.6 of total VC exit capital, 154% higher acquisition exit value, and in terms of doing public exits, they were 5 times more likely to actually make a public exit. And when they did, they were 48.2% higher in value. Okay, so patent assets are really important. It's going to be, it's really important to getting traction with investors and making exits at higher valuations. And this is one of the greatest things about being a patent attorney. Is a lot of times the cost that you are going to pay me or another patent attorney to create these assets is going to be far less than the actual value that is created. I get to create assets that are far more valuable than what you're paying me for. Okay, so we've talked about why companies should care about patents, but why should you as an inventor or as an employee, as an individual care about that if you're not necessarily tied to the company, if you're not one of the founders? From a selfish point of view, one is it's great for your CV. I mean, long term, in terms of what people are going to be looking for in terms of what makes you a great engineer or what makes you a great inventor is being named on patent applications and being named on patent applications that issue as patents. That is extremely important. So think about yourself. That's a that's a great way to build your own resume. But at the same time, by participating in the patent program, by bringing invention to the company, it helps the company, which should help you, especially if, say, you have stock options, things like that. Okay, now I want to talk about different patent portfolios and how we craft them for different types of clients. And I put them typically into 3 buckets. One is going to be large patent portfolios, companies that are they're big, like big companies like Amazon, IBM. I give the example too of large universities. They're going to be put into that bucket, and the way you do patent portfolios for them is very different than, say, startups, which is another bucket, or individual investors or folks who are making small consumer products. So let's start with large company patent portfolio. And I work with a lot of clients like this, and so I'm very familiar with these sort of patent portfolios just as much as I'm familiar with startup patent portfolios and smaller company patent portfolios. So when I talk about large company, we're talking about companies that are filing, maybe 50 plus, hundreds, if not thousands of patent applications per year. And the way that these companies are thinking about patent applications, it's more like VC or angel investing. So for those of you who aren't familiar with how that works, so VCs and angels are going to invest in a lot of companies, and nobody knows what companies are going to be successful or not. Even great investors aren't really going to know. That's why it's a game of numbers. Say, for instance, they invest in 20 companies. They know that the vast majority are going to be a failure. And let's say even half, that they're going to lose their money on half of the companies. And that, maybe there's going to be some of the companies who are going to make some money. Maybe they'll make their money back. And maybe that's going to be, 5 or 6 of those. There's going to be some success with a few of them, but it's going to be maybe that 1 out of 20 companies that's going to be the big home run that's going to make them millions, if not billions of dollars. And that's what they're really shooting for. They know they're not making money on the vast majority of these companies, right? If anything, they're losing a lot of money on these. So that's the way that large companies do patent portfolios. They know, hey, a lot of the stuff, we're never going to make products related to this. This is something that's going to be outdated in a few years. This is a dumb idea that doesn't make any sense. They don't care. They're going to file on everything, right? So that's one of the things to understand about these big companies is they're going to start the patent application process with a non-provisional application. Again, I'll talk about the patent process, provisional versus non-provisional later on. And for them, budget isn't as much of an issue. They know, hey, we just need to invest in a lot of patent assets in a lot of companies, and we have this budget allocated. Okay, their focus is on high quality enforceable assets. That's why they're going to skip the provisional step. They want to make it as streamlined as possible, and they're looking to set things up for cross licensing, the defense and the offense. So they're really focused on they're going to battle it out and try to get the broadest claims possible. That is their focus. They don't necessarily need the optics like startups do, which I'll kind of talk about here in a second. So with these large companies, the strategy pretty much stays the same. And it's one of the things that in some ways is kind of unglorified about the work I do for the big companies. It's kind of churning out sausage. It's like we file patent applications, work with the process, we get them issued. We fight with the examiner, try to get the broadest claims possible. And, it's very much the same. So unlike with startups have a very, very different strategy. And this is some of the difficulty that folks in companies have difficulty with because they've worked at big companies and they're used to that strategy. Or some patent attorneys have this issue as well. They work only with big companies and they apply big company patent strategy to startups and individual inventors just like they would a large company, which is honestly a recipe for disaster. So when I talk about startups, I mean early stage growth companies that scale via investors. Okay, this is going to be companies that maybe they're going to be filing one, maybe up to 10 plus applications a year. It's not a lot. With startups, budget is always going to be a concern. I don't care if you are if you're funding things yourself, you've gotten a seed round, you've gotten some early rounds of funding, you are always going to be bootstrapped. And when it comes to IP budget, you want it to be streamlined as possible. There are so many more things that are important to put your money into: developing the product, marketing, things like that. And so you always want to be considering the budget for IP costs, okay, even as you scale. Part of it is going to be that you want to have a patent portfolio that can be scaled. So in the beginning, when you're extremely bootstrapped, you don't want to make it so that you can't scale your patent portfolio as you get more capitalized. That's one of the important things, is being able to defer costs while at the same time remaining flexibility. And unlike big companies that are just going to file on most any idea, if they think it's going to be even potentially commercially viable, they're going to file as early as possible, and they're going to file on pretty much anything, knowing that a lot of stuff is going to be worthless. It's never really going to go anywhere. It's going to be outdated. But with startups, you can't really do that. You have to focus on the core products of things. And for startups, one of the most important things, especially early on, it's going to be the marketing. It's going to be the optics. You're not going to have the ability to stop other people from doing things. One, it takes a lot of money, which startups typically don't have and don't want to risk, to do patent litigation and to get in these big patent battles. And it's not very attractive to investors a lot of times. They see that as being a lot of risk. So what's really important for startups is being able to claim patent pending status, being able to attract investors, whether it's patent pending or it's issued patents. It's attracting investors, attracting partners. It's setting yourself up for an exit. That is what is most important. It's not being able to stop people and battling it out. That's kind of a big misconception. And unlike big companies, which for them, it's like, hey, we come up with an idea, let's file as soon as possible. We want to get an early priority date because we live in a first to file system where priority is based on who files first. It's counterintuitive, but for startups, it's typically better to delay as long as possible. And what I say is, especially for the early stage with startups where capital is extremely, extremely tight and it's important to allocate it appropriately, I typically tell people to wait until you're ready to make public disclosures, public uses, or offers for sale, because that's when you're going to be forfeiting patent rights. Wait until you're about to do that. Or wait until you're about to approach investors so you can go into investor pitch meetings, be able to say that you're patent pending, that you have patent assets, which is attractive, and you can be more open about it because you have an early priority date before that meeting, so you don't have to be cagey and say, oh, well, I can't tell you what we're doing. Hey, you can go in and say, hey, we're patent pending, we have this all protected, let me tell you what we're doing, and investors are going to like that a lot better. And unlike large companies, startups are going to typically start with a provisional patent application, which kind of dovetails into my next section here, is the two ways to start the patent process. So for big companies, I kind of talked about starting with what is called a non-provisional patent application. So in this diagram, I have the two ways. You start off with you have an idea, and then you're going to, for starting with the non-provisional, you draft this expensive attorney-drafted non-provisional patent application. It's extremely important that an attorney is going to draft this. It has extremely formal requirements, and a lot of times if you do it wrong, you cannot fix things with a non-provisional. So you draft and file this non-provisional patent application. then it waits in line at the USPTO for about 1 to 3 years before examination begins. And the only reason why it takes so long is it's the government. They have a big backlog, and you're just waiting for your application to come up in line and come to the top of some examiner's pile. So that will then, when you come to the top of the pile, it's going to start the examination process. A patent examiner at the United States Patent and Trademark Office is going to pick it up and is going to do a prior art search to determine whether what you have claimed is new and non-obvious over the prior art. Now, it's important to think of this examination process like a negotiation. It's like Pawn Stars or American Pickers, where you expect that there are going to be rejections, and that is a natural part of this haggling process. What you're trying to do is trying to get the broadest claims possible that cover as many variations as possible, and the examiner needs to make sure that what you have claimed is new and non-obvious over the prior art. So sometimes this examination process can take months or years, and there can be a lot of back and forth between you and the examiner. Every once in a while, it's a lot faster. You can get to allowance faster, but assume that there's going to be a lot of back and forth. It's going to be a process that takes months, if not likely years in a lot of cases. So hopefully at some point you convince the examiner that what you have is new and non-obvious over the prior art. The examiner is going to send a notice of allowance, which then will set up a time frame to pay an issue fee. You pay this issue fee, and then your application will issue as a patent. So that's a process of starting with a formal non-provisional patent application. Now, why does this not make sense for startups? A lot of times, doing this formal non-provisional application, which again, you really should have done by an attorney, it's going to cost you anywhere from $10,000 to $20,000 or maybe more to draft and file this really formal application. And for any startup, it doesn't make any sense to spend all that money up front, especially when you're not sure if it's even going to be a viable product, you don't have investment yet. That's why it's good to start with what is called a provisional patent application. Okay, so that's the bottom row here. So you have an idea, the process kind of starts the same, and instead of drafting this formal attorney drafted application, a lot of times you can keep costs lower by having the inventors or the engineers or the folks who understand the technology draft an invention disclosure, essentially a description of the technology, how it's made and used, and that can then be filed informally as a provisional patent application. Or you can have a more attorney drafted provisional if it's really important, or if folks don't have the ability or time to draft to draft this detailed technology description. So provisional patent applications are great for startups. So they are just a placeholder. They only last for 1 year. They automatically expire at the end of that year. And then you have to file that formal non-provisional patent application. But again, provisionals are great. You can do it cost effectively, and it's easier to update them. So for instance, in that year that provisional is pending, if you come up with new stuff, if it's not described in that original provisional application, it may not be covered. So what you can do is you can file another updated quick provisional application, and then at the end of the year when you have to file that non-provisional patent application, you can then add more inventive stuff that you came up with within the year in that non-provisional and claim prior to the first provisional and claim prior to that second provision. So it gives you a lot of flexibility to incrementally protect inventions, which is really important with startups, and that's what typically happens. You will file this provisional application, like I said, right when you're about to make public disclosures, public uses, or offers for sale. And then once you start getting out into the public, you start getting feedback on the product, you start realizing, oh my gosh, we want to make a lot of change, maybe we want to totally pivot and do something different. It's a lot easier to do that cost effectively with starting with a provisional patent application. Like I said, provisional lasts for 1 year, it expires, then you have to file that non-provisional patent application, and then the process is pretty much the same from there. So non-provisional waits in line for 1 to 3 years, examination occurs, that can take months, if not years sometimes, and hopefully at the end, the application is going to be allowed, you pay the issue fee, and the application issues as a patent. So I want to talk to you about some inventing and developing issues. So you're an engineer, you are somebody who is managing a team of engineers, and it's early stages. What do you want to think about? What are the critical things you need to think about when it comes to patents? And these are some of the things I see all the time that will totally derail companies, will make them radioactive to investors, and tank the company before it's even started. So the first one is, do not make public disclosures, public uses, or offers for sale until you file a patent application. The reason is that you start to forfeit patent rights upon a first public disclosure, public use, or offer for sale. So in nearly all foreign countries, you automatically lose patent rights. And in the United States, you have 1 year to file a patent application. Otherwise, you completely forfeit your patent rights. And I see this a lot where people come to me and say, hey, I've been selling this product, for a couple years. It's great. Now I want a patent. It's like, well, you can't. Or what'll happen is people say, well, we're not thinking about foreign rights right now. This isn't really important to us. We just want to, get it out there. We're just gonna go ahead and disclose it and then wait to file our patent application until later. But what happens then is they start looking for investors, and then there are certain investors say, hey, we really want foreign protection in Europe or maybe in Southeast Asia. Can you do that? And I've seen people lose out on deals because they've forfeited their foreign patent rights by saying, we're not thinking about foreign, it's not a big deal. But so the best thing to do is to file a patent application, again, before any public disclosures, public use, or offers for sale. Otherwise, you're going to forfeit patent rights that could be extremely important to you. And like I said, too, you want to file typically before you talk to investors. So when you go into an investor meeting, you can be open with them about what the technology is because you have an early priority date. Even if it's the day before and somehow they want to try to steal the idea or things like that, you have an early priority date and you can use that against them. And going in saying it's patent pending, one, it makes your pitch a lot better. And then not that it happens, it's very unlikely for people to steal ideas, but even if people were considering doing things like that, it's a strong disincentive to do things like that. Also, and I hope that most folks understand this, is do not go into investor meetings asking them to sign non-disclosure agreements. A lot of times they're going to be insulted by that, and it's going to sort of peg you as somebody who doesn't know what they're doing. And you may never even really get any true feedback. They might just smile at you nicely and say, hey, thanks for coming in, or thanks for talking to us. We're not interested, and you'll never know why. And it's probably because you tried to ask for a non-disclosure agreement, which is a huge turnoff to investors. So again, better way to do it: file a patent application, go in and say, hey, we're patent pending on this. It's also important to understand that the United States is no longer a first to invent system. It used to be that priority was based on who invented something first. But now priority is based on who files a patent application first. And that comes to parity with the rest of the world. The rest of the world, it was always a first to file system. So don't think that you get priority just based off of when you invent. Now, again, just because it's first to file and you get priority based on when you file, for startups and most businesses, it makes more sense to wait until you're, again, ready to make public disclosures, public use, or offers for sale, or approach investors. Now, when it comes to being an engineer or running a team, or somebody who is working with your in-house counsel, or typically with small companies, they're going to be having to approach outside counsel, patent attorneys like me. They're the ones who are going to be filing things. It's better to report ideas and inventions than not. Okay, so the standard is, is the invention, is it new and non-obvious to one of ordinary skill in the art compared to all the product that's already available out there? And a lot of times, people are not going to be your average people in the field. I work with a lot of people who are top in the field, and they say, well, it'd just be obvious to me, and I don't think this would be patentable. It's like, look, that's not the standard. The standard is, would it be obvious to one of ordinary skill in the art to combine all the prior art that's known to come to this? And it's like, look, you're not a person of ordinary skill in the art. You're a person who's top in the field. Yes, it would be obvious to you, but that's not the standard, okay? And a lot of times people sort of discount the things they're doing. They say, this isn't that important. This isn't that big of a deal. But talk to your managers, talk to the people who are the ones who are engaging with the patent attorneys, or talk to patent attorneys early, and don't just discount the ideas that you have, or even small incremental things. Sometimes a tiny little improvement can be something that is really important intellectual property for the company. So talk to your manager, whoever it is making decisions about intellectual property. Bring the ideas forth. It's better for them to say, maybe this is patentable, maybe it's not worthwhile to file, or this isn't patentable, instead of having some really important multi-million-dollar idea slip through the cracks because you said, I don't think it's that big of a deal. Okay, so how can you, as a person who is an engineer in a company, somebody who is inventing things, or somebody who is a founder or an executive, how can you help with the patent process? So first thing is, like I said, bring ideas to the people above you, or bring them to the attention of a patent attorney. You're a lot of times going to be giving up on really important ideas if you don't just bring a lot of ideas to the forefront. Let a patent attorney sort of triage them and say, hey, this would be patentable, but given what you're looking to do with the product, it may not make sense. The ROI is going to be low on that. Maybe we shouldn't file. Or yeah, this is something that's really important. I know it may not seem like a big deal to you, but this is going to be something that's going to be really important blocking technology for competitors. We totally want to file on this. This will totally be patentable. It's not something that's obvious or not something that's not novel. Also, prevent public disclosures, public use, and offers for sale before patent applications are filed. So even if you're somebody, say, who is in marketing or you're doing collaborations, always have it in the back of your head, hey, if we're working with other people who are external, check with the patent attorney or check with somebody higher up. Make sure we filed patent applications first before doing this, because you don't want to forfeit patent rights. Okay, and I talked about provisional applications being a great way to start the patent process for startups. So one thing that folks, who are the engineers and the scientists and folks like that, they can draft detailed invention disclosures about what the technology is. And one of the biggest things that scares people is they say, well, I don't know how to draft patents. I don't know what to do here. Like, this is scary to me. It's really not that hard. And at least what I do with my clients, I send them a really basic template that has instructions. And really what it pretty much says is, hey, it's all about content over form. You want to have something that describes the technology in sufficient detail that your average person in the field could make and use the technology, would understand how it works, maybe understand the user experience. So that, for instance, here's a good example. So if you had to outsource it to somebody else and you had to provide them a guide of like, okay, how do you make and use this thing? You give them this guide and they could do that. That's the sufficient level of detail that needs to be in this technology disclosure that then can be filed as a provisional application. Doesn't need to have flowery patent language. It doesn't need to be written in any specific form. It's a form that makes sense to you, that describes the technology. Okay, and that's the biggest thing that holds people back. It's like, well, I want to spend all this time, I want to draft patent claims, or I want to, have this flowery patent language. Like, no, don't do that. I would rather have stream of consciousness and stuff that is, written in technical form than people spending a lot of time having polished prose and trying to sound like a patent attorney. I always think about it in the sense of, there's only, think about like a glass of water. You only have so much energy in there that's going to go into drafting a patent application. Where do you allocate that energy? That energy should just primarily be in drafting the description of what the technology is and how it works. It shouldn't be things like on the background about, here's what the prior art is, and, focus on what your technology is. That's where you're going to get the biggest return on investment. And that's for the provisional application process. So what typically will happen there is I will take a description like that. I will script it to make sure there's not limiting language and file that as a provisional patent application. Sometimes if we need something to be a lot more formalized, we may put more attorney time into that. But a lot of times it's most cost effective for startups to start with an invention disclosure that is scrubbed and filed as a provisional patent application. So for the non-provisional stage, so again, you have this provisional, it lasts for 12 months, automatically expires at the end of the year, and you have to file this detailed formal non-provisional application that needs to be drafted by a patent attorney. So for this, the way it typically works is the patent attorney is going to hold an invention disclosure meeting where they're going to talk to the inventors and say, hey, let's sort of push the boundaries on this. What are some alternate ways to do it? We want to be able to claim this as broadly as possible. And also to be able to talk about, are there any updates, things that have changed in the year since you filed that provisional patent application? Those are going to be the main things that you're going to be asked to do as an engineer when it comes to the non-provisional stage. And a lot of times it's not all that difficult. Sometimes these meetings are going to be maybe an hour at the most, and maybe you may have to prepare by kind of looking through the provisional application, see if there's any updates. If there's major updates, you may need to provide some of those details, but it shouldn't be that difficult. Usually the non-provisional stage, surprisingly, is actually a lot easier. And part of this is because startups at that point, they're going to be getting traction. They initially, they have more time than they have money, whereas a year later, they're probably going to have more money than time, or at least the time of the engineers and other folks is going to be a lot more valuable. And so then we try to keep the time cost of those folks to a minimum. So those are the important things that startups really need to know. And if you want to see more stuff, check out this video as well. It's got, or actually I think it's going to be over here. Check out this video. It has a lot of more stuff about startups and patents. You're going to love it. So thanks for watching, and we'll see you again in the next video.